Hello, everyone. Good morning, good afternoon, and good evening. Thank you for attending this webinar. This is Fan Zhen from SPTL, and I will be the moderator today. As one of the leading IP firms in China, SPTL has been providing full range of IP services for decades. Today, one of our patent attorneys, Ms. Wang Di, will share with us a very interesting topic about design patents in view of the recently amended Chinese patent law. Ms. Wang Di joined SPTL in 2017 after finishing her master program. Her practice involves patent drafting, prosecution, re-examinations, third-party observation, and infringement analysis in the field of mechanical engineering. She also provided a lot of filing strategies.
Hello everyone, I'm Di Wang, a patent attorney from the Mechanical Patent Department of SPTL. Here's my greetings from Shanghai, China. I hope you and your loved ones all stay healthy and well under this pandemic situation. Today, I would like to present you with some new information regarding the first revision of the patent law in China, especially with focus on protection of designs. In the first section, some background information about this first revision will be presented. First, let us take a look at the timeline of this first revision. The preparation of the newly effected first revision to the patent law actually started 7 years ago. Here on this slide, you may find a general timeline for this revision. Actually, in the past 7 years, public opinions from IP practitioners, academic professionals, individual inventors and designers, entrepreneurs, and manufacturers in China and in foreign countries have been consulted, collected, and reviewed. The draft of the revision has also gone through several times of amendments already. Now, this revised new law has officially taken into effect since June 1st, 2021. And this revision shows an intention of a stronger protection of patent rights in China. In particular, the revision could be summarized as the 3 parts now shown on this slide, and also involved the improvements of the prosecution system. A great change in the prosecution system as related to the designs, which is also the focus of today's discussion. Later in the third section, I will also take a glance at the first plan, the strengthening of the protection of the legitimate rights and of the interests of patentees. Due to the time limit today, my discussion will focus on the change to the design protection system. One of the purposes of this revision is to keep in line with the Hague system. The Hague system provided by the Hague Agreement greatly facilitates the applicants to protect their industrial designs across the world. Actually, according to the Hague Yearly Review for the year 2020 published by WIPO, China ranked the 9th among all the origins in 2019, despite the fact that China is not yet a contracted party of this agreement. The applications from China are now filed by the Chinese applicants who may have business locations in the membership countries of this agreement. And with the revisions we are just going to discuss in the next sections, it could be said that the law system for design protection in China has now also become harmonized with the law systems for design protections in some major markets for Chinese manufacturers. Also, according to the published working plan of the China National Intellectual Property Administration, CNIPA, for this year, One of the focus will be to continue working on the acceleration of China to join the Hague Assembly. Also, according to CNIPA, back to last year, 2020, the particular text for China joining the Hague Agreement has been confirmed with WIPO already. So with this revised patent law, and upon China being a member of the Hague Assembly, an obvious growth of design applications in China is to be expected. Moreover, more foreign applicants will try to protect their industrial designs in China with the assistance of this Hague system. And now, at the last slide of this section, I would like to bring you an overview about design patents in China. Here, let's go to the first number. By the end of year 2020, there are in total more than 2.1 million effective design patents in China. And the second number here, in the year 2020, more than 700,000 design patents have been granted. And the last number here, you may be interested, how long does the average examination duration take for a design application? And the answer is that in the first half year of 2020, the average duration is about 3.2 months. I hope you can have a panorama of the design applications and design patents in China with all these three numbers. And now let's go to the next section of my webinar. We are going to see what's actually new about this revision of the patent law in perspective of design protections. First, let's see what's new for the prosecution stage. The first change is a longer protection term for design patents. Previously, the protection term for an invention patent is 20 years in China, while that of a design patent was 10 years, and also 10 years for a utility model. Now, according to the new patent law, with a design application filed on or after June the 1st this year, that is 2021, please take a note on this date. Once granted, the protection term of this design patent will be boosted by 5 years, reaching 15 years. Actually, this is also an adaptive revision of the patent law as a preparation step for China to join the Hague Agreement later. That is to say, with such a revision, the protection term for design in China also reaches the minimum requirements of the Hague Agreement. However, please note that according to a proclamation issued by the CNIPA, design patents that are granted on or before May 31st, 2021, or their design applications that are still pending during the time now that is still pending after June 1st, 2021, but filed before this date, once granted, they still only enjoy a protection term of 10 years. And now let's go to the second change point of this revision. So the second highlight here is actually about domestic priority. Now with the revision, a priority can also be claimed from a design patent application within 6 months from the first filing in China. However, before this revision, a design application could claim priority from a first filing in foreign countries, but not from a first filing in China. This somehow led to an imbalance. And now I will show you a detailed example to further illustrate this imbalance on the next slide. Let's see, for example, previously in China, an applicant, for example, a manufacturer of caps for thermos bottles as shown here. He filed a design application to protect the design of a cap. This cap was going to be launched to the market soon, and it was like the one on the left you see here. However, before this cap was finally released, the R&D department of the applicants may have made some further discussions, and now the actual product shown here was the one that actually launched to the market. You can see that the design of the final product of this cap is similar with the one filing in China earlier, but there are still some slight differences here between them. So what would be the problem is that when you first filed this application for this design in China earlier, before this June, later, if the applicant would like to actually protect the design of his product here, he may need to file another application for design patents. However, now the problem comes. The earlier design filing in China could probably constitute a conflicting application to the later one, since they both were essentially similar. However, if in another scenario, the manufacturer first filed the design for the caps shown on the left here in a foreign country, they may later claim the priority of this earlier filing and still file a new design application in China, claim the priority and protect the design of the actual released product here. So now you see that as an imbalance between the design first filing in China and the first filing in foreign countries. Greatly as that, with the new revision, for both scenarios we have just discussed, it is possible to claim the priority from the earlier filing, regardless of where it is filed first. And this would help the manufacturer of the thermos caps. So you can see the domestic priority offers a balance between first filing in China and abroad, as we have just mentioned. This amendment provides further time and space to the R&D department of the manufacturer to furnish their designs and products for at least 6 more months. Similar designs originating from continuous improvements of the product are also possible to be claimed under this new Article 29 of the Patent Law. Generally, this revision will bring benefits to those applicants who first file a design applications for their products in China. And in this case, most of those applicants will be domestic applicants. However, if you or your client have a branch or an entity in China, they could also benefit from this revision. And another important change with the new patent law is a partial design. Now, partial design can be claimed in China, which will be in line with the practice in many countries or regions in the world, like the US, EU, Japan, and South Korea. Previously, a part of the design of a product could not be claimed for protection in China when that part cannot be separated or that part cannot be sold and used independently. For example, the neck of a bottle, the handle of a mug, and the ear of a vase. Here you can see the whole design of a vase is possible to claim, but the ear only, no, it's not. And now with the revision, with partial designs being able to be claimed in China, such a problem can be solved. This beautiful and unique handle of the mug can be claimed protection under partial design, and also this ear of the vase with proper handling of the whole design, it can also be claimed for protection. So who will be benefited most from partial designs? There are many answers, but I would like to say that in one situation, for those products with only few degrees of designer's freedom, partial designs also helps to better reflect the key point of design. For instance, this one shown here is an example found from a judgment made by the Supreme People's Court of China at the end of last year. It is a chargeable electric driller, and according to this judgment made by the SPC, this kind of product generally consists of a driller head, a driller body, a handle, and battery parts. So in this case, there are not so many degrees of designer's freedom for this kind of product left. The difference between the products of this kind, a chargeable electric driller from different manufacturers, may only sometimes lie in very small points like the shape of the driller head, the shape of the handle, and here the angle formed between the handle and the driller body. The great news is now with the partial design can also be claimed the manufacturer of those products could also better reflect their essential design points with the partial design, and they would also have a better protection against a potential infringement in the future. So as we have just discussed about the main changes of the design protection system in prosecution stage, now I would like to present you with some points of the revisions related to the protection of patentees and their interests. Those are also naturally of great importance to the patentees of design patents. First, with the revision this time, the patent evaluation report system has also been changed. As background information for you, since utility model and design do not go through so-called substantive examination during the prosecution stage in China, the patent right of a utility model or of a design is usually not so stable as that of an invention patent. So thereby, a patent evaluation report system has been adopted since 2009 in China. Since then, when an infringement dispute over a utility model patent or a design patent take place, the People's Court or the local patent administration may require the patentee or the interested party that would may be a licensee to present such a patent evaluation report, and this report will later serve as an evidence for the adjudicating or handling of this disputes over patent infringements of design patents or of utility model patents. And here you can see actually a patent evaluation report is also used for the patentee to apply for recordal with the customs to protect the intellectual property of their products related to a utility model or design patent. It is also sometimes useful in IP licensing and IP transaction for evaluating the stability of this patent right of a utility model patent or of a design patent. And also it is useful for the patentee to protect rights at e-commerce platforms such as Ali or Taobao in China. And here, actually before this revision, this evaluation report system could only be applied by patentee and interested party. And now with this revision, it is also possible to apply by an alleged infringer voluntarily. And further, for the background information of the patent evaluation report, since this system has been adopted, the number of requesting a patent evaluation report for design patents alone has seen a gradual increase. By year 2017, the total amount of the request of applying a PER for a design patent is already more than 30,000. This fast growth somehow also proves that the patent evaluation report system is an effective supplementary to the current examination system for design patent applications in China. However, due to the huge amount that we have mentioned for the request of a PER, it now takes about 2 to 3 months for the CNIPA to prepare such a report on average. And now let's go back to the revision. As we mentioned in the past, only the patentee or the interested party is allowed to apply the presence of such a report from the CNIPA. Now with the revision, the alleged infringer as well as the patentee and the interested party can also voluntarily apply for such a report. And with the report at hand in advance, for a dispute over design patent infringement, for example, the patentee and the alleged infringer can both have a reasonable expectation on the concerned design patents. So sometimes they may even reach a settlement before bringing the dispute to court. This definitively will save both the time and the effort from both parties for the resolution of this patent infringement disputes. And let's take a further example here. For example, if the alleged infringer requires a patent evaluation report for a concerned design patent from the CNIPA, and later he got this report. However, this report shows a positive conclusion about the stability of the patent rights of the concerned patents. In this situation, it is greatly advisable to this alleged infringer to first reach out to the patentee and to get a settlement or even a license, and this will definitely save the time and effort for him. However, if the applicant if the alleged infringer here in our case still would like to take the usually countermeasure that has tried to invalidate this design patent, we will suggest that he shall at least pay more attention and take more time to prepare the materials for the potential invalidation, considering that the patent evaluation report has provided a greatly positive conclusion of the stability of the concerned design patents. And now to the second part. For the patentees of all types of patents, another important point of this revision is a stronger protection of their interests. This is reflected in two aspects here: a higher statutory compensation and the punitive damages. The statutory compensation for patent infringement used to be from 10,000 Chinese yuan to 1 million Chinese yuan. And now with this revision, the upper limit and the lower limit for this statutory compensation has both been greatly raised. That is from 30,000 Chinese yuan to 5 million Chinese yuan. You can see a great growth here, and according to our opinion, this will work well to hinder the potential infringers to some extent. And talk about the punitive damages. Since China is not a common law country, punitive damages used to be seldom in civil litigations. However, in recent years, to strengthen the protection of intellectual property rights and also to show the world our determination, punitive damages have been gradually introduced to the sector of competition law. Now, the patent law has also established such a punitive damage system for patent infringement cases with serious circumstances. Such a punitive compensation may be awarded to the patentee, which can be added up to 5 times of the compensationary rewards, and you can see it is even higher than the 3 times upper limit in the US. Those two new provisions also apply to patentees of design patents, and here we would like to show you a recent case. This is a case tried recently in China, in Shanghai, actually earlier in this year. Shanghai Intellectual Property Court has made a first instance judgment. According to this judgment, 4 defendants shall stop infringement on 3 design patents of Casio, the well-known electronic watch manufacturer from Japan, and a compensation of in total 8.8 million Chinese yuan shall be paid by those 4 defendants. In the judgment, the court listed out 6 factors that were taken into consideration when the judgment was made. 2 of them are worth of notice. First, the defendants are considered to copy the product with the protected designs of Casio in bad faith of infringement. And second, the 4 defendants refused to provide related accounting materials. Even the court had ordered them to do so. With the new law, perhaps those 2 factors can lead to the establishment of a serious circumstances which we have just mentioned. And in this case, it could lead to an even higher compensation to the patentee. And now we come to the last section of today's webinar. We would like to provide you with some tips for partial design applications in China under this new law, and also a prospect from our side as to be provided to you. At current stage, what concerns the most applicants around the world about the revision of the design protection system in China could be how to file a partial design application. For this question, we would like now to provide you with some tips. Those tips have already been summarized on this slide. According to a proclamation from the CNIPA, applications of partial designs can now be filed at first. However, those applications will later be examined once the revision to the implementation regulations has been passed. In this case, if you would like to claim a priority and to file a partial design application in China, we suggest filing the application as late as possible, but remember still within the priority deadline, since the revised implementation regulations could be published at any time. A further correction might be available in this way. And to the second tip, if the time has come, the deadline is coming, and it is not possible to wait any longer. And if in the priority application, the claimed part of the design has already been distinguished from the unclaimed part of the design in some way, we will suggest filing the application in China based on the set of drawings in the priority application as is, and waiting for further notice from the examiner to correct or amend the drawings if there is any notice. In this way, the respective formal requirements of a partial design application could also be met. And if the applicant finds it necessary, it is also applicable to state in the brief explanation of the design about, for example, the intended use of the solid lines and the dashed lines or the shadings in the views, or perhaps about the key points of the partial design of this application, like, for example, which particular part of the design is intended to be claimed by the applicant in this application. According to our past experience, if the examiner, however late, finds any contents in the brief explanation being inappropriate, the examiner will still offer the applicant with a chance to remove those contents during the examination stage. And in addition, as to the possible way that would be allowed to distinguish the claim part from the rest of the design in an application in China after this revision, although there are no official guidelines so far, we may have a hint from an article that has recently published by the Department of Design Examination of the CNIPA. This article initially takes a review about how partial designs are expressed in different countries across the world. Here, we would like to provide you with two screenshots of this article. You can see here the left one and here the right one. They are both screenshots of the article. On the left side, the use of the combination of broken lines and the solid lines have been exemplified by the department, and it has been used in a US design patent. And to the right side, a Japan design patent has been exemplified to show that semi-transparent covering or shading could also be used in a design patent application to protect partial design. That has to cover the unclaimed part with this shading here, and the rest shall be the parts for which protection has to be sought by the applicant. So in this case, although no official guidelines have been provided by the CNIPA, we consider it of high possibility that Both of those two ways shown here would probably be allowed by the CNIPA later in an application of a partial design. And further, we would like to make a prospect from our side at the end of this section. Given the fact that only the revised patent law has been published, we now expect that the revised implementation regulations and the guidelines of the examinations, and also perhaps further proclamations from the CNIPA will also be provided to the public soon. Actually, after the law has been revised, some questions have now already been generally discussed across the IP practitioners and some academic professionals. And also they have given some different answers. Those questions are now waiting to be officially answered by the CNIPA. And we have also cited some of those questions as an example here on our slide. For example, people and especially some applicants would like to know, will it be allowed to file a partial design application claiming priority from a full design application? And what about the reverse case? Will it be allowed to contain a full design and a partial design in the same application? And as we have also just discussed, what will be the officially allowable ways or the officially accepted ways to express a partial design to distinguish the claimed part and the unclaimed part from each other? We would like to see the answer to those questions provided by the CNIPA soon. And also, for the protection of design patents, we would like to provide you another trend. According to an aim set by the CNIPA this year, the resolution of patent infringement disputes related to design patents will be accelerated. And also about the patent evaluation reports that we have just mentioned, the preparation stage of a patent evaluation report for a design patent will be shortened in this year. And this comes to the end of my introduction about the revision of the patent law in China, in particular about the design patent protections today. I hope the information we just provide you would be helpful for you and your clients to protect their design patents more effectively as well as more efficiently in China. And thank you for your listening.
Okay, thank you very much for your sharing, Dee. It's really informative and helpful. Now, let's check if anyone has any questions. If anyone has any question regarding the presentation, please feel free to input your questions through the text message box. Now, let's check. Okay, here's one question from Pfeffer Andrea regarding the patent evaluation report. His question is, if a requester is not satisfied with the conclusions in an evaluation report for the concerned design, can he argue about this conclusion? Let me repeat it. If the requester is not satisfied with the conclusions in the patent evaluation report for the concerned design, is it possible for the requester to argue about this conclusion?
Well, thank you, Mr. Fan. This is actually a good question. And to the answer is, it is possible for the requester of the patent evaluation report of the PER to request a correction within 2 months from receiving this PER. And according to the examination guidelines, if the administration that has the CNIPA find that there are mistakes, like for example, the facts of the findings based on which the conclusion as made as obviously erroneous, a new patent evaluation report will be provided in this case. And however, if there is not any mistake found by the CNIPA, no new notice will be sent from the administration. Actually, this is not in the case like, for example, a substantive examination. The requester, for example, the applicant in the substantive examination is not satisfied with the conclusion given by the examiner and try to argue with the examiner, and later the examiner applies again to the patent, to the applicant or to the requester in our case. Actually, for the correction process of a patent evaluation report, only when mistakes were found, the patent evaluation report will be corrected. And if no mistakes were found, and even the requester is not satisfied with this conclusion, for example, maybe a negative conclusion, this patent evaluation report will sustain. I hope my answer will bring enough information to you. Thanks.
Okay, thank you, Dee. Here again, another question still from Mr. Pfeffer-Andre. His question is, now the partial design can also be a subject matter of design patent application in China. So is there any change to the protection of GUI under the revised patent law? So let me repeat it. Is there any change to the protection of GUI design under the revised patent law?
The answer is yes. You can see now with partial design also allowed in China. At least the drawings will be different and the subject matter can be focused. Let me take this into detail. Previously in China, a GUI application is filed with a screen-board panel, and usually the screen-board panel, the contour line of this screen needs to be drawn in solid lines. And in this case, the screen display panel, which carries the GUI, is also a subject of the design application. Now, partial design is available, so we may choose to join the contour line of the screen for the display screen panel in dashed lines, which means we do not intend to claim this part. And in this case, we will show that our intention for protection, the essential design points for this application as the graphic user interface, the design of the interface itself. However, please note that unlike some other regions in the world, in China, the design application still needs to attach to certain products. That is to say that graphic user interface itself still does not constitute a product in the sense of China law. And in this case, it is not possible to directly protect the graphic user interface as a single product alone. However, if your graphic user interface does solve some particular technical problem, it is now practical in China to protect this graphic user interface as a software product with a invention patent. And I also hope this would be helpful to you. Thanks.
Thank you, Dee. It seems that there are no more further questions for the time being. Okay, so if any audience today still have further questions later, you are still welcome to write us by email. Today, from this introduction, we may expect a stronger protection for design with the new patent law. But currently, we are still waiting for more details from the implementing regulation of the patent law, which is upcoming. And we will keep you well informed of any updates. Our next webinar will be scheduled at the end of this July, focusing on interpretation on amendment to the patent examination guideline. So please follow our post or notification. I think that's all for today's webinar. Thank you for being with us and hope to see you next time. Have a good day. Bye-bye.
Bye-bye.